Ladies and gentlemen, financial trailblazers and guardians of tomorrow's wealth, welcome to today's legal webinar. My name is Koketso Mepeng, NBC Holdings Compliance Officer and your host for today. Now, in the next 2 hours, we're not just talking regulations. We are arming you with tools to turn them into superpowers. Now, let's get real. The Financial Sector Conduct Authority has just dropped reshaping how we educate and empower our clients. I'm talking about Conduct Standard 1 of 2025 that sets out requirements for financial institutions providing financial education initiatives. This is the blueprint for delivering fair, impactful financial education initiatives that truly move the needle on financial literacy. This is effective from March 2026. Now, this standard isn't only about box ticking. It's a call to action for every financial institution to design targeted programs and measure real outcomes like knowledge gains and behavioral shifts. And we need to also report with transparency and build trust and inclusion. No more hidden marketing ploys. This is about structured, measurable education that protects vulnerable groups and drives genuine financial well-being across South Africa. Now, here's the exciting part that got us all buzzing. To supercharge compliance and ensure our sessions hit the mark, going forward, our webinar invitations will ask you to furnish a bit more information upfront. Think quick details, nothing invasive. Just enough to tailor content that's laser focused on your needs and to track the transformation impact we're creating together. It's all in line with the standards push for data-driven evaluation so that we can prove and improve how we're elevating financial smarts nationwide. Examples of such questions are on the chat box. The first one is based on demographics. What best describes you? And the second and the third one are based on knowledge. Now, with that foundation set, let's turn to our first speaker, who will speak things off with a dive into a landmark case that's reshaping how we approach dependency assessments. Before I introduce my first speaker, there is a poll question on your screen relating to this particular case. And the question is, when do you think a person's dependency should be determined for purposes of a Section 37C death benefit allocation? When do you think a person's dependency should be determined for purposes of a Section 37C death benefit allocation? There are 4 options. Please choose one that you think is correct. Now, a warm welcome to our first speaker, Ms. Gyabethu Matai, legal advisor at NBC, who will help us with the correct answer. She will be presenting on understanding dependency in death benefit allocation, exploring the nuances on the recent case ruling and its implications for trustees and dependents. Ms. Gyabethu Matai, the floor is yours.
Good morning, everyone, and thank you for joining us. My name is Gyabethu Matai, and I will take you through an important judgment and highlight exactly what this ruling means for trustees, administrators, and as well as HR representatives who are involved in the management of death benefits under Section 37C of the Pension Funds Act. So I'm going to focus on the Chifiwa Shembri Mutila versus Municipal Gratuity Fund Constitutional Court ruling that clarifies the key issue we have all struggled with at some point, that being when exactly dependency must be determined. Is it at the date of death of a member or at the date of distribution of the death benefit? So let's begin with going through why this ruling is so important. Firstly, it directly affects the way we investigate and allocate death benefits. Secondly, it clarifies the timing of dependency, which has been an area of confusion for quite some time. And thirdly, it reinforces our responsibility to protect genuine dependents, ensuring that those who are truly dependent actually do get a portion of the death benefit. And obviously, this will be dependent on the evidence that is provided by the identified dependents. And finally, it does also help us with ensuring that we are in compliance with the principle. So this case is not just an academic ruling. It shapes how funds act, how funds record their findings, and how funds justify their decisions. Let us recap the facts briefly. So on the 15th of December 2012, the deceased member, Mr. Takalani Mutila, an employee of the Palabora municipality and a member of the Municipal Gratuity Fund, passed away, and a death benefit of approximately 1.6 billion rand became payable. He was married in community of property to Mrs. Chifio Mutila, and together they had 5 children. In 2009, the deceased member completed a beneficiary nomination form listing his wife and 5 children as beneficiaries. However, he also had another relationship, a life partner, Ms. Dipuo Masete, who lived with her own children and her mother as well. And before the member passed away, he took out a funeral policy naming Ms. Dipuo Masete, her children, and Ms. Dipuo Masete's mom, as well as his own children and his mother as beneficiaries. The life partner later alleged that she and her children were financially dependent on the deceased. So the fund considered both households, the wife and the life partner, as potential dependents. And after investigation, the fund concluded that the wife was self-sufficient as she was employed as a teacher. It found that the life partner and her children were factually dependent on the deceased. So the fund allocated the death benefit as follows: 22.5% to Mrs. Chifua Mutila, and 27.5% to Mrs. Dipuo Masete, and the remaining portion of the death benefit to the 7 children, and it was apportioned according to their needs. And obviously the wife challenged this decision, and that challenge set off a long legal journey. So Mrs. Chifua Mutila's main arguments were that one, Mrs. Dipuo Masete was not married to the deceased. In actual fact, Ms. Chifua Mutila had obtained the services of a personal investigator, and that report that he submitted to her revealed that Mrs. Dipuo Masete was married to Mr. Masete, and that Dipuo's children were born out of that marriage. And secondly, the main argument was that Mrs. Dipuo Masete and her children were not financially dependent on the deceased. So this complaint journeys through the pension fund adjudicator, the High Court, the full courts, the Supreme Court of Appeal, and ultimately it reached the Constitutional Court. And the legal issues that were raised here was whether the fund conducted a proper investigation into dependency as required by Section 37C. And it also went to address when dependency must be determined. Is it at the date of death or at the date of distribution of the death benefit? And it also questioned that once a person qualifies as a dependent, whether they must still be a dependent at the time of the distribution of the death benefit. And it also looked into the standard of review for trustees' discretion, whether just showing a process is sufficient or whether funds must go a further step by ensuring that their decisions are reasonable. So the Constitutional Court delivered a clear and decisive ruling. Importantly, the court overturned the earlier Gunnery approach, which had allowed dependency to be reassessed at distribution. The court also held that dependency must be determined as at the member's date of death. And it also stated that once a person qualifies as a legal or factual dependent at that date, being the date of death, their status does not change if their financial circumstances evolve thereafter. However, that post-death changes may legitimately influence the allocation of the death benefit awarded to that identified dependent. The court further criticized the fund for conducting an inadequate investigation. It also held that the fund failed to substantiate factual dependency with objective evidence, and that it had relied heavily on assumptions. The fund was thus ordered to conduct a fresh investigation. So let me just quickly take you through the reasoning behind this outcome. So the court adopted a purpose-driven interpretation of Section 37C. So the phrase "upon the death of a member" is what identifies the point in time for determining dependency. So a further note is that dependency has two dimensions, is what the court said. The first being that the status of dependency, this would then be interpreted as to whether a person was dependent on the member at death, and the second being the extent of dependency. So how much support they required, which may then affect the amount that is allocated. So what the court said here is that only the second dimension can change over time. The first dimension is fixed at date of death. So another thing that the court did was to reiterate the trustee's discretion, and it said that it must be exercised lawfully, reasonably, and procedurally fairly, and that funds cannot hide behind a process. If the investigation itself is shallow or unsubstantiated, then it will not stand scrutiny, the decision that is. So what does this mean for us? It means that trustees and administrators must anchor their investigation at the date of death, not at the date of payment. In other words, the list of potential dependents must be drawn upon based on the facts as at date of death. Funds must also ensure that they conduct robust evidence-based investigations. This means actively tracing dependents who are financially or legally dependent on the deceased as at the date of death. Funds must also document and minute all decisions. The fund's rationale for recognizing or even excluding dependents must be clear and defensible. Funds must also distinguish between dependency and allocation. So a person remains a dependent even if later events alter the amount that is due to them. And lastly, funds must avoid relying on nomination forms and affidavits. Remember that nomination forms are a guiding tool and they cannot replace factual inquiry. So same applies with affidavits. Another thing that would need to be done by funds would be to ensure that they review their Section 37C policies to ensure that they explicitly state that dependency is at date of death. They need to also review checklists and templates that they have currently to ensure that the investigation is one that extracts objective evidence. And also the minutes that are documented, these need to also reflect clearly the reasoning behind the identification as well as the allocation of the death benefit. And one thing that also needs to happen is that trustees need to be trained and to ensure that the principle that has been established through this case is adopted. Okay, so let's just quickly summarize the shift. So under the old Guneri approach, dependency could be assessed at any stage, even close to distribution of the death benefit. So what that means is that someone could actually lose recognition as a dependent if their financial circumstances changed after the death of the member. And under the Mozilla case, dependency is fixed at date of death. What may change after the date of death is the actual allocation portion that the trustees would have decided upon. So this new approach gives us clarity regarding identification of dependencies. But obviously, clarity doesn't necessarily remove any risks. So the risk that the fund may face if they don't comply with this principle would be legal risk. So any allocation that is based on wrong timing or poor investigation can be set aside by a court. We also face reputational risk in the sense that families rely on funds to ensure that cases are not mishandled. So this might have an impact on the trust that the family members have on the fund, and as well as administrative risks. So redoing an investigation, which oftentimes when the decision of the trustees is set aside, would mean that the implication is that we have to reallocate benefits, for instance, and that has cost implications. And obviously it also causes delays. Okay, so what needs to happen for trustees is that, or rather funds, is that they have to review death benefit processes. So does it link dependency at date of death? They need to update forms and checklists to ensure that investigation templates and nomination forms reflect this standard. They need to also train stakeholders such as trustees and HR representatives and administrators so that they understand practically what dependency fixed at death really means. And also one thing that funds can do is audit the cases that they have that are still pending since this judgment has been passed, and also communicate clearly to members and beneficiaries so that their expectations may be managed, and also make clear what it is that is required from them in terms of documents and evidence. And one last highlights from what this implication has for us as trustees is that you need to document and record evidence that you are using to rely on or that you have applied to ensure that Section 37C principle is applied to. And most importantly, what we would also encourage funds to do is to collaborate between trustees, HR, and unions, because when investigation process is transparent, disputes are obviously then reduced. So in closing, remember the core principles from this judgment, one being identification of dependents is fixed at death. Changed circumstances post-death affect only the allocation, not the qualification. Financial needs and circumstances must be thoroughly investigated. Relying on nomination forms or unverified affidavit is inadequate. Equitable does not mean equal. Section 37C demands fairness based on needs, not identical shares. And process must be documented. So proper minutes, evidence records, and reasoning has to be noted so that your decision can be justified. So next time you sit in a trustee meeting and you are faced with a death benefit allocation, ask, have dependency been assessed as at date of death? Has the fund gathered objective evidence of factual support? And has the fund documented its reasoning? And is the decision equitable and defensible? And if the fund can demonstrate these core principles, then the decision will almost always stand up to scrutiny. So this concludes the case law update on Mozilla versus Municipal Gratuity Fund. And as trustees, HR reps, and administrators, our duty is to ensure that the purpose of Section 37C, which is to ensure that those who are dependent are protected, is upheld. I appreciate your attendance, and again, remember to be guided by the Mozilla principle, and thank you once again. Over to you, Gogeto.
Thank you, Ms. Matai, for that compelling overview of that particular case. It's a stark reminder of how Section 37C's mandate demands rigorous scrutiny without compromising fairness. Thanks once again. Can you give us the correct answer to the question that was posed before your presentation, please?
All right. So the answer is that dependency, the identification of someone as a dependent, is fixed as at date of death. So what you as trustees, administrators, and HR representatives would have to do is that you'd have to look at the facts that present themselves as at date of death to identify potential dependents.
Perfect. Thank you once more. We're shifting gears to the recovery landscape. Our next speaker will unpack a critical intersection of debt recovery principles and insurance safeguards. The application of the duplum rule alongside long-term insurance protection in pursuing contributions that are in arrears. In an era of economic volatility, where employer defaults on pension or provident fund payments are all too common, understanding how these tools limit interest accrual and shield policyholders is essential for trustees, administrators, and legal advisors alike. It is my pleasure to introduce Mrs. Nandi Pangobo, NBC's senior legal advisor, who brings unparalleled depth to this topic. Mrs. Ngobo, over to you.
NBC Holdings aim to be the leader in people benefits in Africa. Our mission is to provide cost-efficient financial services which are tailor-made to suit your organization and employees' needs, in order to provide them and their dependents the financial security they need should they die, become disabled, or retire. Visit nbc.co.za for more information on our competitive fee structures. NBC is an authorized financial services and credit provider.
Thank you, Koketso, for that amazing introduction, and thank you, Kia, for your presentation. It is very informative. Good morning again, and as Koketso has said, my name is Nandi Pangobo, and I'm in the legal department. So today I've been requested to provide training, or rather a discussion on the case law of Blue Crane Root Municipality versus the Municipal Workers Retirement Fund. So what does this case speak to? So as Koketso has said, this case dealt with the principle of the duplum rule. And I know that sometimes principles similar to these ones may seem a bit confusing at first, but before I get into the actual case, I thought it would be appropriate to first explain what the duplum rule is, what it seeks to protect, and the purpose for duplum in terms of your pension fund contributions. So importantly, as I discuss this case, it is a case that affects contributions, rather arrear contributions that employers need to then pay. I will also go through the conflicting judgment of Umzimkulu that was heard in 2023. So the current position is that we have the Blue Crane matter, which is the subject of this particular case law update, as well as the Umzimkulu matter, which then conflicts what the Blue Crane matter says. And in closing, I will discuss the stance of the pension funds adjudicator. And the reason for bringing this particular adjudicator stance is because when there is a dispute, or when there is a complaint rather that relates to a member's contributions, usually members would then approach the pension funds adjudicator. And it's important to understand how the adjudicator will then review this particular matter that I'll be discussing. So by way of introduction, what is duplum? So duplum is a legal principle that limits how interest can be calculated and how interest accrues on a debt. So what this means is that, for example, if you have a debt or an amount that you owe that is 10,000 Rand, the interest that can accrue on that particular amount cannot be more than 10,000 Rand. So essentially, what the in duplum rule seeks to do is to cap the interest, the calculation of interest, or the accruing or the running of interest. And why does the in duplum rule try to do this? It prevents lenders from allowing interest to accumulate checked firstly, which could otherwise trap borrowers in a cycle of unpaid debt. So essentially what is happening here is that if you have an amount that you owe, the interest cannot be more than the actual amount that you owe. And you would understand that from a paying perspective, that if you continue to pay interest that continues to run, that is uncapped, it might prejudice you if you are the one that is supposed to be paying that amount. So now that we understand that the principle of in duplum seeks to cap interest or the calculation or the running of interest, that it doesn't override the actual amount, why is this principle important for your pension fund contributions? Or why is it even discussed in the pension fund space? So importantly, as a member of a fund, your employer is required in terms of Section 13A of the Pension Funds Act to contributions. So what happens is that by virtue of you being an employee and a member of the fund, your employment agreement would then direct that your employer would deduct a certain amount from your remuneration. And if the agreement is that the employer also contributes a portion, which is the employer's portion, then these two amounts, the amount that is deducted from your remuneration and the amount that your employer is liable to pay, is known as your contributions. These contributions are in terms of your fund rules, and they need to then be paid to the fund not later than 7 days after the end of the month for which such contribution is payable. So this particular slide is taken exactly from the Pension Funds Act. And because the employer's requirement to deduct and pay over these contributions is in terms of the Pension Funds Act, we view this as a statutory or a legal obligation to do so. So now that we know that the employer needs to deduct and then pay over contributions at a certain time, what happens if your employer does not comply with Section 13A? So what Section 13A, subsection 7 then says is that if the contributions doesn't reach the fund's bank account by the time that is specified in the fund rules or in the act, then interest at a rate as prescribed shall be payable from the first day following the date when it expires. So from the 7th day or that grace period or the day that is in the act, if your employer has still not complied, then the contributions that are owed starts gaining interest. And this interest in the pension fund space, we refer to it as late payment interest or LPI. So this LPI, why does it why do we have LPI? Time. And it also protects, or it seeks to protect, the financial interest of members of a fund. It ensures that the fund is not disadvantaged by late receipt of contributions, which could affect investment returns. Because essentially, if the employer was compliant with Section 13A, they were deducting and paying over contributions at the correct rate and on time, then your contributions would be invested on time and you would then enjoy investment growth. But because of the default or the non-compliance of the employer, that essentially makes the member and the fund lose out on investment growth. And that's why interest or LPI is then accrues on that contributions that is outstanding. So now that we understand that if the employer does not pay over contributions, interest attracts those contributions, we then need to understand how does the fund calculate that LPI or interest. And this is why we'll be discussing this case, because it essentially then directs the fund to calculate whether the interest will be subject to the in duplum rule. So is the interest capped, or does the interest continue running until the employer pays the contributions. And the blue crane matter will try to answer those questions. Okay, now to get into the facts of the matter. So the applicant, who is the municipality in this matter, failed to deduct the correct pension fund contributions. So I'll pause here and just explain that if the employer does not pay your contributions on time, that amount attracts interest. Also, if your employer deducts an incorrect percentage, that means that the employer is underpaying your contributions, and that outstanding amount also then attracts interest or LPI. So this particular case, that's what happened. They were deducting contributions and then they were paying them over to the fund. And this non-compliance happened between 2007 and 2013. So in the application that gave rise to the audit, the fund rules for the period of rules required the applicant to pay over to the respondent, or which is the fund, contributions for 7.5, that was for the employees' contributions. So this is the amount that was supposed to be deducted, or the percentage that was supposed to be deducted from the members' remuneration. And the employer was rather paying over 5%. So you can see there is a discrepancy between the 7.5 that was supposed to be paid and the 5% that was actually paid. And then also the employer then was deducting 12% of their contributions rather than 18%. So accordingly, the case put forward by the respondent was that the lower contributions attracted LPI, and then they were non-compliant in terms of Section 13A. Apologies. So once this matter then was heard, then the fund granted the court rather granted the fund a judgment. And then this judgment was granted on the 26th of November, 2019. And in the judgment, what the court then said was that the municipality needs to make payment of 3.8 million rand. And this amount was for the contributions that were outstanding. And then the court then said that over and above the contributions that are outstanding, the fund also needs to pay interest. The employer rather needs to pay interest. But you would note that from the judgment, they didn't exactly say the amount of interest that needs to be paid. It just said that interest would then need to be paid based on the contributions that are outstanding. So if you look at the amount, which is 3.8 odd, and the amount that the fund then sent to the employer. So then when the fund then requested the contributions to be paid together with interest, the fund then requested, or the attorneys of the fund then requested the employer to pay 30 odd million rand. So you can already see that there's a difference between the 3.8 million and the 30 million that the fund is now asking. And this 30 million includes interest. So the municipality then made payment of the 8.4 million. So the municipality paid firstly the contributions that are outstanding and then paid interest. But the interest that the municipality paid was not the interest that was requested by the attorneys of the fund. And what the municipality then did is it approached the court. And in approaching the court, they said that it is unreasonable, firstly, for the fund to request interest that is over 20 million rand for contributions that are roughly 8.6 million rand that is owed. And the municipality then asked the court to make a ruling to say that the interest then needs to be kept, and the in duplum rule needs to then apply on how the interest is calculated. So the court's consideration. So in dealing with this matter, the court reviewed the legal history of the in duplum rule, which prevents unpaid interest from exceeding the outstanding capital amount of the debt. The court indicated that the rule is a common law rule that regulates the accrual of interest on a debt that is due and payable. And the overarching purpose of the rule is to protect debtors from being crushed by the never-ending accumulation of interest on an outstanding debt. So then the fund then argued that the Pension Funds Act needs to be interpreted to exclude the in duplum rule. And you would understand this because essentially, if the in duplum rule is not applied, then the fund would have a higher claim from the employer. The long-standing argument has always been that contributions are governed by the Pension Funds Act and therefore are a statutory obligation. And this is different because the Pension Funds Act is the one that directs how the contributions need to be paid and when the contributions need to be paid. And then we note that the interest or the late payment interest payable by employers rises because of the Pension Funds Act. So then this would then be reviewed as a statutory or legal obligation. And the treatment of interest is then covered in Section 13A, subsection 7 of the Pension Funds Act. The legal argument has been that because this is a statutory obligation, then the common law would not be applicable. That means that you would not cap the interest that needs to be calculated. So in considering the fund, the court then in response said that, firstly, it is always presumed that legislation does not alter the existing law more than is necessary. The court then said that there is no reference to the rule in the Pension Funds Act and no express wording to support the contention that the legislature intended to exclude the rule when the interest is payable. So essentially the court is saying, the only thing when I review the Pension Funds Act that I see is that it tells you that contributions need to be paid by the employer, when the contributions need to be paid, and if the contributions are not paid, then interest accrues. The Act, what the court is saying is that the Act does not necessarily say that because contributions are governed by subsection 7, then that automatically means that the common law no longer applies. So if the legislature wanted to change that position to limit the application of the in duplum rule, then they would have expressly mentioned that in the Act. So in the absence of that, then the court then said that the in duplum rule applies. The second argument of the fund was that it relied on the framing of Section 103, subsection 5 of the National Credit Act. And this section then says that despite any provisions of the common law or a credit agreement to the contrary, the amounts contemplated in this particular section that accrue during the time that a consumer is in default under the credit agreement may not exceed the unpaid balance of the principal debt. So essentially what the fund was trying to then say is that Section 103 then limits it to credit agreements, where in this particular instance, it's different because it's a statutory obligation that arises from Section 13A. And the court then indicated that Section 103 of the National Credit Act has been held to embody no more than a specific rule. So it is essentially saying that you can't extend this to then mean that in duplum only and it excludes the Pension Funds Act. In the absence of the legislature not expressly indicating that, the position would then be that the common law applies, and even when there is contributions, area contributions, it does not necessarily mean that the in duplum rule would only then be applicable to credit agreements or debt that is recognized in the National Credit Act. So in concluding this particular case, the court declared that the interest payable by the municipality is limited to the application of the in duplum rule. That then means that the calculation that the fund then needs to apply is capped. So it can't be more than the contributions that are owed. So the 30 million that the fund initially requested would then have to be recalculated and then in light of the in duplum rule. So why this then raises a confusion in the industry currently is that prior to the Blue Crane matter, there was the matter of the Umzimkhulu matter that was heard in the High Court in the Pietermaritzburg court. So essentially, in Umzimkhulu, what the court then said that is in duplum does not apply to area contributions, or LPI. And their reasoning was that LPI arises because of a statutory obligation. And because there is already legislation that governs LPI, or interest that accrues from area contributions, then the common law would not be applicable in this particular instance. And this then raises a confusion because both matters were heard in the High Court. And if you have conflicting judgments where both are in the High Court, then it becomes a persuasive authority, meaning that a High Court in one jurisdiction may choose to follow or depart from a conflicting decision in another based on the strength of its reasoning. So then we have confirmation from the attorneys that were representing the fund that they have then received leave to appeal. So what this means is that the Blue Crane matter will be suspended pending the outcome of the appeal in the Supreme Court of Appeal. But interestingly, although they have received leave to appeal and you even have a conflicting judgment of the Umzimkhulu matter, the adjudicator was very quick to issue a communication, which is Communication 1 of 2025. And in this communication, what the adjudicator then said is that as the pension funds adjudicator, we align to the determination or the judgment that has been issued in the Blue Crane matter. And essentially what this means is that when there is a matter before the pension funds adjudicator, what will happen is that when the fund is calculating how much the employer owes the fund in terms of late payment, interest, as well as contributions, they would then have to apply the duplum rule. And then they would have to cap the interest that is that. So the member impact is that LPI will then obviously now, if the matter is referred to the adjudicator, it would be affected because the calculation of the fund would then mean that duplum applies and you cap the interest. And the whole purpose of LPI and not applying the duplum rule to LPI was to compensate members who are affected by employers who are non-compliant. And now that LPI will be kept when matters are referred to the adjudicator, although the matter is still on appeal, it essentially means that the fund has no choice but to apply the duplum rule because of Communication 1 of 2025. Clarity will then be received once the matter is heard at the Supreme Court of Appeal, and then a judgment will then be made. Because essentially, once the matter is with the Supreme Court of Appeal, we will then follow that direction. And then matters after the Supreme Court of Appeal will then be directed whether the duplum rule will apply when we calculate LPI or whether the duplum will not apply. And that's where I end my presentation. Thank you very much for listening, and I hope it was informative. And we will update you once we have confirmation of the outcome at the Supreme Court of Appeal and whether the duplum rule will apply to area contributions. Thank you so much.
Thank you, Mrs. Ngobo, for that masterful breakdown of the duplum rule boundaries and the LPI's role. Excellent insights as always. Thank you so much. In an evolving labor landscape, our next presentation by Ms. Nicole Makoloko, NBC's legal advisor, tackles a timely intersection of family rights and fund obligations based on the implications of parental leave on retirement fund contributions. Welcome, Ms. Makoloko. Please illuminate this vital topic. The floor is yours.
Thank you, Koketo, and good morning to all of our attendees. Thank you for making the time to attend our webinar today. As Koketo discussed, today I'm going to be speaking about an important topic. Whether you are a parent, a soon to be parent, whether you're planning to become a parent, whether you're not becoming a parent, this is going to affect all of us. What I'm going to be speaking about, as you see on the screen, is a judgment that was handed down on the 3rd of October by the Constitutional Court, and it's called the Van Wyk and others versus the Minister of Employment and Labor. So this case basically is talking about parental leave. That's the new term that we're going to be using for today. There's no more maternity leave, there's no more paternity leave. It's now all called parental leave. So let me give you a background about this case firstly. So this case comes from a long-standing situation in terms of how the labor laws dealt with parents differently in terms of leave and different kinds of parents. So under the Basic Conditions of Employment Act and the Unemployment Insurance Act, birth mothers, fathers, adoptive parents, and commissioning parents meaning those that go the route of surrogacy in order to have a child, all of these types of parents were treated differently in terms of leave. So in short, what we previously had before the 3rd of October when this judgment was handed down was birth mothers were entitled to 4 months of maternity leave. Fathers only got a limited amount of leave, which was usually just 10 days, and adoptive or commissioning parents had a separate version of leave, and also their entitlement was usually less favorable than the birth mothers. So in this case, we had the applicants, which was Mr. and Mrs. Van Wyk, and they were actually joined by several advocacy groups. That's why you see Van Wyk and others. There were other advocacy groups that wanted to fight for these rights for all types of parents. And they argued that this type of leave was unfairly discriminating against parents, and it firstly violated constitutional rights in terms of equality, which is Section 9 of the Constitution, and in terms of dignity, which is Section 10 of the Constitution. So at the heart of this case, the court reflects how families have truly changed. Parenting is no longer just about a mother's role, and the law needed to recognize that. The law needed to modernize in terms of what is being reflected today. So share caregiving arrangements rather than, clinging onto that old, outdated gender norms type of understanding of how parenting works. So what the court found was, I'm going to give you a short and brief analysis on it. It found that firstly, there was unfair discrimination that was happening. And it was based off of what? It was based off of your gender. It was based off of whether you're a birth mother or not a birth mother. So the court found that that current system that we were under, it unfairly discriminated against certain types of parents. So in particular, treating mothers and fathers differently purely based on gender and outdated assumptions about caregiving is discriminatory. Giving adoptive and commissioning parents less leave than birth mothers, or applying things like age limits, was arbitrary and unjustified, right? And then whilst the court also found that these were discriminatory against, adoptive and commissioning parents, it also understood that it's reasonable to also remember that a birth mother requires recovery time before and after a child is born. And so whilst that is taken into account, it does not now justify excluding other parents from a meaningful time with their child. So the law's assumptions that fathers or other parents don't play an equal caregiving role is outdated. The court also looked at equality and dignity. It highlighted that equality and dignity are central in this specific context. Both parents must be able to participate equally in early caregiving. And the law should not confine fathers or other parents to just the sort of minimal or supportive roles, while mothers are seen as main caregivers. So on top of that understanding of what the court found, they handed down what's called an interim relief and a suspended declaration. So what this means is the court declared that parts of the law were invalid, meaning immediately after this court specifically says that the law is invalid, it automatically should no longer apply. But in this case, obviously, it's difficult to change these types of laws overnight. So what the court did was it said, we're going to give Parliament an opportunity to fix this problem. Now, in the first matter where it was heard in the High Court, the High Court gave Parliament 2 years to amend legislation to come into line with this judgment. But then once it went all the way to the Constitutional Court, the Constitutional Court said, no, we're actually going to give Parliament 36 months to rectify the legislation. But for now, in the meantime, the interim regime will apply. So what does this interim regime mean? It means that the concept of maternity leave, which was just a benefit for birth mothers, falls away completely. It's fallen away already. And it becomes a unified concept that we're now going to call parental leave. So all parents, all types of parents are going to get 4 months and 10 days of leave, which, now hold on, before everyone gets excited and starts thinking that, mother and father are going to get 4 months of leave. We're not there yet. What it means is from that 4 months and 10 days, parents can either share those 4 months and 10 days, whether they choose to do it at the same time, whether they do it one after the other, or whether they split it between themselves. However, each parent will be allocated 4 months and 10 days, which they can combine together and decide who will take which portion when. Now, if there's only one parent that's employed or a single parent, then that parent can take the full period, that full 4 months and 10 days. Now, this entitlement also applies to adoptive and commissioning parents. So before, adoptive and commissioning parents did not get the same types of benefits depending on the employer that you had and what policies they had in place legislatively. They did not have the same kind of benefit as a maternal mother or a birth mother. So an example of this is in the old rules, it said that an adopted child had to be under 2 years old in order for an adoptive parent to be able to take the full amount of leave in terms of the 65 days that's allocated to them. The court said in this judgment that's going to be removed. We're not going to put these random age gaps just because this is an adoptive parent. But they didn't actually give a cap or an age which will apply. They said Parliament will have to decide the new age threshold at a later stage. So within the next 36 months, Parliament has to discuss this and decide what is going to be the new age gap. But for now, that age cap has fallen away. Now, the other issue that the court looked at, but didn't really go into depth at all about it, was the issue of UIF, the Unemployment Insurance Fund. We all know it as UIF, and that UIF benefit, what's going to happen to it? So the court said, you know what, we're not going to deal with this. Once again, we're going to say that Parliament needs to address this in depth and decide how they are going to practically change the UIF benefit and how it's going to work at a later stage. So these are just a summary of the measures that reflect the approach that was set out in the judgment. So why does this judgment matter? So in terms of the industry that we're in, from the perspective of administrators, employers, funds, this is going to be a major shift. It's going to be quite a big one for all of us to take into account. That's why I said, whether you're a parent or not, whether you intend to become one or not, as long as you're employed or part of a fund or in this industry, we're going to have to look at this in depth. So it's moving away from that gender role, birth-focused view of parental leave, and it's looking at now focusing on a more equal and inclusive framework that recognizes all the different routes there are to become a parent. So employers and funds need to review their leave policies, contracts, collective agreements, handbooks to ensure that we all apply as stakeholders in the industry with the interim regime and prepare for the future legislative changes. The judgment is quite important because it actually reinforces dignity of parents. It recognizes that being a father, being an adoptive parent, or a commissioning parent via surrogacy, it's not a secondary or lesser role. Being a parent is just as important. There's a mother, there's a father, there's mothers, two fathers, commissioning parents, adoption, and all of that type of parenting shouldn't be discriminated against purely based on being a birth mother. So for funds, the link is going to be between the leave entitlements and the UIF benefits, and how it's going to actually affect the benefit structures that funds have in place, and how funds will need to actually adapt now to this new legislation, or rather this interim regime that we're going to be under. So including for employers as well, this is going to be very difficult as well. There's a lot of change that needs to happen. Employers that are participating in umbrella funds or offering additional benefits like paid top-ups or company paid leave, they also now should review those benefits and ensure that they're not going to indirectly discriminate against one parent versus a different type of parent. So let's go into a little bit of depth and guidance as to what should employers do? What are some practical steps that employers can start taking right now in terms of this judgment? So in terms of the policy and contract reviews, firstly, employers need to now replace all references to maternity leave, paternity leave, adoption leave, commissioning leave with one single term, and that's going to be called parental leave. So all documents that you have that speak to these types of leave have to be changed to parental leave. Employers will have to make sure that their policy allows for both parents, regardless of their gender or how they became parents, to share the 4 months and the 10 days as they choose, or for one parent to take the full period if they're single. Employers now also have to include clear processes for disclosure when both parents are employed. So this one's going to be a difficult one practically, because what if you have two parents that don't work for the same company and they want to share the leave? If they don't disclose that, how will you know as, employer one of parent one, if parent two is also taking the full 4 months and 10 days? So we have to start thinking of these types of things. Are we going to ask for affidavits maybe? Are we going to ask for the parent at your company who's employed by you to provide a letter from the other parent's company to also give a letter to say that they will be sharing the leave, the dates, or if they're not going to, etc. Those are some things that we already have to start thinking about right now. So employers also have to keep in mind that birth mothers still need time for recovery physically. That's before and even after birth, okay? So whilst that's being considered, there's no additional time for the recovery time of a birth mother. So it's still included in the 4 months and the 10 days overall. So even though maternity leave has quote unquote fallen away, a birth mother will not be permitted to come back to work if she physically is unable to do so, or has been approved by a doctor that she's able to come back, even if she wants to share the parental leave. So that's going to be an important thing to watch out for as well. Employers will also have to now look at including provisions for stillbirth or even third trimester miscarriages. So the court here noted that parenting begins when the child becomes part of the household. And so policies should also reflect compassion and practicality together. For situations such as adoptive parents or commissioning parents who went through surrogacy, employers will have to now also think of, how do we get the proof of you are a commission? Are we going to have to ask for things like a court order under the Children's Act, or a surrogacy agreement, or even adoption finalization papers? So those things have to be considered by you as an employer as well. And where collective agreements apply, start the discussions early with trade unions to update agreements in line with this interim system that we have right now. Eliminate the gender-based or root to parenthood differences. Those discussions need to happen right now. Don't wait just for Parliament to come back with legislation, because as I said, because of this judgment, these laws are already in place. Maternity leave, commissioning leave, adoption leave has all fallen away. We are falling under parental leave now. So sticking to what employers should be doing, but now we're going to talk about the operational and maybe administrative readiness. We've thought of ways that we can also start assisting with how employers can do this. Firstly, you'll need to update your HR systems to include the single parent leave category. Okay, so ensure that payroll, leave tracking systems, they allow for the flexibility for shared or split leave between parents. Employers need to train their HR teams and their managers so that everyone understands the changes and don't assume that only birth mothers are entitled to this leave. And then in terms of the training, another important thing is going to be communicating these changes clearly to your employees and even participating funds in terms of updating your funds with your new policies, especially where an employer is part of an umbrella fund. It's really going to be important if you're a participating employer, part of an umbrella fund, to have that coordination, to have that communication be clear, direct, and open, and work with your fund as well. Then you also need to make sure that you keep an eye on the legislative progress. So remember, whilst this judgment is in place, Parliament still has been given the 36 months to actually effect legislative changes. So we need to keep a lookout for what's going to change now in terms of the law. And we need to ensure that, once again, when those laws become effective, we'll have to review policies, contracts, etc., and make sure that we apply those and implement them in terms of legislation as well. Employers will also need to review their associated benefits, whatever other benefits that you provide to your employees. So things like paid versus unpaid leave, your company top-ups, as I mentioned, just to make sure that they apply equally and they don't indirectly discriminate against one type of specific parent. And lastly, one thing I want to highlight is that employers need to, like I said, ensure that they are having an open communication of transparency between their umbrella funds, and umbrella funds as well need to review their rules and ensure that they are providing communication to their members and ensuring that this regime is being implemented and it's being spoken about and that people know about it as well. So now I'm going to speak about what are the implications of this judgment on retirement funds. So since I assume most of us who are attending this webinar are in the retirement fund industry, the judgment has some specific implications for us all. So firstly, for retirement funds, umbrella funds with multiple participating employers need to remember that employers' leave policies directly affect fund communications, contribution flows, and benefit calculations. The extended leave entitlement might actually impact the contributions or even service continuity for a fund. So funds need to look out for that and start preparing for it. Trustees need to also be alert to discrimination risks. Okay, so that's very important. So if an employer's policies differ by gender or the type of parenthood that they are in, it can create a legal and also a reputational risk that can affect a fund. So it's important to also keep that in mind as a trustee of a fund. In terms of a retirement fund's SLA with its administrators, it's going to be very important to anticipate now how a contribution is going to be collected, because now leave patterns are going to change. You're no longer just going to see birth mothers going on leave. Leave patterns are going to change, and we need to start looking at how do we now ensure that we are ready for that leave pattern to take that drastic change, especially once communication goes out about this new regime. So lastly, in terms of funds need to prepare accessible, simple, member communication, explaining how the new parental leave regime works, especially for adoptive or commissioning parents. It's going to be very important that funds are also active in terms of informing members about this new regime and working with employers as well to ensure that this message goes out and it is being implemented as per the judgment and also as per what Parliament provides in terms of legislative changes. So in terms of also risk management, funds need to ensure that they aren't seen as being complicit, right, to discriminatory practices by employers they work with. So in as much as a fund and an employer and a participating employer want to have that healthy relationship of transparency, of being able to note what is happening, how a fund can assist an employer and how an employer can get assistance from a fund, it's important not to be seen as a fund that actually co-signs the discriminatory practice of providing, quote unquote, maternity leave versus paternity leave. We can't be seen as doing that as funds. So trustees need to ensure that they're already looking at these issues. So that said, even though funds don't actually set leave policies, trustees still should be aware of the broader compliance environment. So this isn't just about employers need to make sure that they change their policies. It's also to the fund to ensure that funds, trustees, administrators are all looking at this as well, because it is, like I said, going to affect the contribution flows as well. So here are some key takeaways that I want to give regarding this discussion and this case. The current parental leave system is changing. The old categories, like I mentioned, the maternity, the paternity, the adoption, the commissioning, those are all changing. Those are all called old categories now. And they were unequal in entitlements, and that's why they're no longer deemed as constitutional. They're deemed as unconstitutional. So they have fallen away. All parents, regardless of their gender or how they became a parent, have to be treated equally. And like I said, in this judgment, the court already gave an interim regime, whilst Parliament has its 36 months to provide actual legislative changes. And that is going to be that 4 months and 10 days of parental leave is shareable between the parents, both parents. And if it's only one parent working or one single parent, then that parent has the entire 4 months and 10 days, regardless of their gender or how they became a parent. Employers, like I said earlier, need to start updating their policies and their contracts now already. Don't wait for this to happen later, because you'll find yourself in a situation where someone has to go on to maternity leave, or rather parental leave, but you'll still be calling it maternity leave in February, and you could be slapped with a discriminatory litigation or lawsuit against you because you weren't already working on changing your policies to ensure that you are already compliant. In terms of funds and trustees, please, you need to include parental leave implications in your governance oversight, especially around member benefits and employer compliance. That needs to be something that's put into your risk management, your risk matrix, etc. And you need to be monitoring that and checking on your employers as well to see if they are complying with the current legislation. This will also assist you in predicting the patterns, the leave patterns that are coming about, and being able to ensure that you're able to maneuver and shift and ensure that your contribution flows are not being affected negatively because of being unprepared regarding this matter. And as I said earlier, this decision reflects a broader issue regarding constitutional values. So equality, dignity, and the recognition of diverse family structures. This isn't about mothers versus fathers. It's about parenting and it's about care. So don't look at this judgment and go, this is about mothers versus fathers and, etc. It's not about that. It's about parents need to both be able to have the opportunity to be there for their children, especially in the early stages of their lives. Any type of parent, mother, father, etc. And then also, just to add on to this, the last point that I want to take away from this is that Parliament, as I said, still needs to discuss the UIF benefits and how that's going to be affected in detail. And they're going to provide us with those legislative changes. So we need to all be vigilant to the changes that may be arising. The leave entitlements are already right now clear and enforceable. So as I said earlier, as employers, don't just sit and wait for Parliament to provide legislation. Start having these discussions, start having the policy changes, get legal advice if need be, in order to assist in ensuring that there's a smooth and proper way of implementing this judgment as well. And lastly, what I want to discuss is what I think everyone should look out for, what all of us as stakeholders in this industry need to watch out for. And that's going to be, as I said, legislative amendments, firstly. Keep track of the Basic Conditions of Employment Act. Keep track of the UIA changes. Make sure that your policies are updated once the new laws take effect. So keep those on your radar at all times. Guidelines and regulations. Watch out for guidance from the minister or even the Department of Labor on how the new parental system will work, especially in cases of commissioning parents, surrogacy, or adoption cases. So once again, that's just about keeping an eye out on looking for what guidance are we going to get from legislature. But in this instance, we can also look forward to most likely the Minister or Department of Labor probably coming up with something and some kind of communication to provide the industry as a whole with some guidance on this. In terms of collective agreements, as I said, employers that are covered by bargaining councils, funds that have bargaining councils now need to come to the drawing board, sit at a table and renegotiate any agreements that offer less favorable terms than what this new regime has implemented. So that's once again going to be a massive task in terms of ensuring that all these stakeholders come to one table and discuss the changes that are going to be implemented in terms of this judgment. And then the issue of the admin coordination. So as I said earlier, it's going to be quite cumbersome for companies to figure out when parents are working for different employers, what needs to be done. Employers need to start thinking of solutions now. How are you going to be able to track the shared leave between parents who work for different companies? Start thinking of those kind of practical implications now and start working on managing them now already. The UIF side, remember I said it's going to likely change. And it's going to most likely affect how benefits are claimed or how they're funded. Employers and retirement funds should also be ready for those adjustments and be ready for how they're going to affect contribution flows as well. And lastly, just in terms of this judgment, the point that I wanted to raise, as I've said before, is that this judgment is actually setting a strong precedent for future discrimination challenges. So where policies lead to unequal outcomes for parents, beware. So it needs to be done expeditiously. Companies, employers need to start changing their policies now, because this is going to open you up to a lot of liability and discrimination litigation against your company if you happen to not have the new interim regime in place. So that is just my summary on the Van Wyk case and how we are now moving into a new wave where there is no maternity leave, there is no paternity leave, there's just parental leave. And in the industry as a whole, we all need to be aware of this and start making the changes. Thank you. Back to you, Koketso.
Sure, what a topic. I have questions, our attendees have questions, so I'm really looking forward to that Q&A session. Thank you, Ms. Makologo, for that exploration of parental leave's ripple effects on fund contributions. Truly invaluable guidance for all of us in the trenches of benefits administration. Thank you. Now, as we build on these themes of employer accountability and member protection, our next session delves into the statutory scaffolding that underpins death benefit distributions. Section 37D of the Pension Funds Act and the enduring lessons from the Plaskon-Evans principle. It is my distinct honor to introduce our last speaker, Mr. Leap Fasel, Executive Head of Legal and Compliance at NBC. With years of hands-on experience guiding funds through regulatory mazes and resolving tough pension cases, Mr. Fasel is a go-to expert who keeps things practical and straightforward. Mr. Fasel, we are ready for your expertise. Over to you.
Thank you very much, Kuketso. I'm not always sure about the expertise. It could actually be just something as simple as age. But nevertheless, it's great fun to be here today. Shweta, I included a poll question. Can we put it up, please? If you don't mind. And it relates to this slide that we all would have seen in the media. Mr. Jacob Zuma has been ordered to pay back 28.9 million rand in legal fees. And the media came out and commented on the possibility that his pension may be used to pay back these legal fees. And with that, I think that's the appropriate introduction for that poll question. Shweta, please pose it for our audience. We're going to give it a few more seconds, and then maybe a bit later, you're going to bring up the results. So we definitely have clever delegates here. Ten more seconds. And it looks like the answer that is winning is the right answer. And it is yes, but it's more complex. And towards the end of my presentation, I will explain to you exactly why that is and why the second most popular answer that has been posted by our audience is no. And I will explain why that is the second most popular option chosen by our delegates. So this is why I chose this topic. I think it is topical. It's something we deal with a lot as employers. And you will see that I titled my presentation today, You Break, You Pay. Now, when I was a child, there used to be signs in shops that said, you break, you pay. And it meant if you touch the wares on the shelves and they fall and they break, you will be held liable to pay for it. But in the context of retirement funds, it means something a little bit different. So it deals with employer damages that are suffered due to dishonest misconduct by employees. And Section 37D of the Pension Funds Act that allows you under certain circumstances to deduct those damages. Then secondly, what are the fiduciary duties of trustees, if any, in this regard? And does it matter, thirdly, whether the Pension Funds Act applies to the factual scenario or not? And we'll answer that at the end. So just as an introduction, I want to remind you that retirement benefits are sacrosanct. Section 37A of the Pension Funds Act says that your benefit in a retirement fund cannot be ceded, attached by your creditors, and it cannot be used for anything other than your retirement. And there's an interesting decision dating back to 2015 now that I quoted there for you in the slides. And by the way, we'll make these slides available to you after conclusion of the webinar. In this particular case, the creditor tried to attach a portion of Mr. Gilbert's benefits to satisfy a debt that was due and payable to her. And the adjudicator ruled correctly that Section 37A of the Pension Funds Act makes that impossible. You cannot attach a person's retirement savings for purposes of paying a debt. So what are the allowable deductions? So Section 37A says you cannot use your retirement benefit for payment of debts or other responsibilities, except for, and there are 5 or 6 exceptions to this general rule. The first of which is income tax. You know, they say that there are only 2 things in life that are certain, and that is death and taxes. So I made a reference here to a very interesting case that I picked up on the topic of income tax. It's Pitt versus the Commissioner of SARS, and it was issued from the Gqeberha High Court in 2024. It is an interesting case because Mr. Pitt raised a few constitutional arguments in trying to recover an amount of about 146,000 rand that was deducted from his retirement annuity. So just the history, Mr. Pitt submitted that he was entitled to a few tax deductions over a number of years. SARS didn't accept those deductions. Mr. Pitt then declared a dispute with SARS, but SARS said, sorry, Mr. Pitt, your objections to the non-allowance of these deductions have been filed late. Then SARS went and attached an amount of 146,000 rand from his Alan Gray retirement fund, and Mr. Pitt launched an application in the Gqeberha High Court to get those monies paid back to him. And he raised a very valuable argument in that first bullet point, in that we grew up, me definitely, in a dispensation where deductions in terms of the Tax Administration Act was not necessarily deductible from a retirement benefit. I got used to a dispensation where deductions under the Income Tax Act itself, and more specifically Schedule 2 of the Income Tax Act, were allowable deductions from your retirement benefit. Mr. Pitt then secondly argued that Section 37A(1) protects his benefit from being attached for debts. And he said, in the third place, that he has a constitutional right to Social Security. So he said this deduction was unconstitutional. The court did not agree with Mr. Pitt and said that Section 197 of the Tax Administration Act overrides Section 37A of the Pension Funds Act, and SARS was entitled to deduct those monies from his benefit. And then importantly, from a constitutional perspective, is that the High Court found that SARS's actions constituted a reasonable limitation under Section 36 of the Constitution. Just as a brief background, we all have a Bill of Rights and inalienable rights, but they're only inalienable to the extent that they hurt other constitutional objectives. A good example in the current context would be freedom of speech. So people say horrible things on social media, and then they say, but I'm entitled to freedom of speech. Well, that's not entirely true, because under Section 36 of the Constitution, certain rights under certain conditions can be limited. Bottom line, go and read that case. It's an interesting decision. Income Tax Act is an allowable deduction from your benefit. The second one is housing loan guarantees. That is actually a very easy one. If you took out a pension-backed home loan using Section 19(5) of the Pension Funds Act, the fund would be entitled to deduct the outstanding balance of that loan when you leave the fund. That also includes what I call other housing loans in the slides. That's where an employer issued a housing loan to one or more of its employees. Just a cautionary note, if there are employers who do this, they have to make sure that they also comply with the National Credit Act. But that's an aside, and it's got nothing to do with our topic for today. Then the third category of deductions that can be made from a person's benefit is damages for dishonesty. That's our topic, so I'll get back to that later today. Then medical scheme subscriptions and insurance premiums to a long-term insurer. Then pension interest awards in terms of a divorce order. maintenance orders, and then tax in respect of divorce payments and maintenance orders. Those are the deductions that are allowed from a member's benefit in terms of the Pension Funds Act. That brings, and I highlighted that in red because I think a reasonable person listening to me will have the following question. What about admin costs, insurance premiums, investment fees, and fund expenses? These amounts definitely reduce the benefit that the member receives at the end of the day, né? And Section 37A says that a member's benefit may not be reduced except as prescribed by Section 37D. But 37D does not mention admin costs or investment fees. So can it therefore be said that the deduction of administration costs and investment fees contravene Section 37A of the Pension Funds Act? And the answer to that is actually no. And maybe we can deal with that as a separate topic in a next webinar. Section 14B, capital B of the Pension Funds Act actually defines what a member's minimum benefit or minimum individual reserve consists of, and that is member contributions plus employer contributions plus investment returns plus OC stands for other credits, and that can be, you know, disability proceeds, whatever the case may be, surplus. And then importantly, minus X. And Section 14 capital B defines X as such reasonable expenses as the board determines. Now that would typically be those items: admin costs, insurance premiums, investment fees, fund expenses, audit expenses. So deductions of costs incurred in the administration of your benefit does not contravene Section 37A of the Pension Funds Act. Right, so now we get to the actual topic for today, and that is deductions for damages, occasioned to the employer due to the dishonesty of an employee. Section 37D allows a retirement fund to deduct compensation from a member's benefit. Number one, for damages caused. Number two, by their theft, dishonesty, fraud, or misconduct. This deduction requires either that the member has admitted liability in writing to the employer, or that a judgment has been obtained against the member in a court. And then lastly, a very elementary requirement that we sometimes forget, and that is that the fund's own rules must actually permit such a deduction to be made. Now, the trustees have certain fiduciary duties. By and large, the application of this particular section of the Pension Funds Act has been driven by our various courts, and then more specifically the pension funds adjudicator, both of which fora have interpreted this provision to include aspects that are not explicitly included in the wording of the section itself. So the section in the Act consists of 5 or 6 lines, but what you learn from my presentation further onwards is that there are a lot of nuances that trustees simply have to take cognizance of before they'll be able to withstand scrutiny by a court or the pension funds adjudicator. And that is the purpose of today's presentation, is to tell you what is not written into Section 37D and hopefully provide you with insight as to how these things can be taken care of in a safe and risk-free manner. All right, so when Section 37D talks of the retirement fund being able to deduct from a member's benefit the damages, it actually means withhold. You have to read the word withhold into the wording of that section. Why do I say that? So the section says that the deduction should be made when the benefit accrues to the member. But when the member becomes entitled to receive his retirement benefits, when he leaves, when he's dismissed, when he resigns, whatever the case may be. Employers would not have been able to establish that employee's liability to compensate them by means of legal process. So both the pension funds adjudicator as well as our courts have adopted a purposive interpretation to this provision to say, because there is inevitably going to be a time delay between the member leaving your employment and you obtaining either a written admission of liability or a court order, you must also have the power to withhold that benefit. And that has been stated quite perfectly in the SCA decision of Highveld versus Oosthuizen that I quoted on that slide. The SCA said if a retirement fund doesn't have the power to withhold the payment of a benefit, then the protection of Section 37D actually flies out the window. It becomes useless. So the SCA's approach actually recognizes that there are practicalities involved when employers pursue delictual or criminal damages against their employees. What is very important, and when I get to my final slide in this topic, I'm going to tell you that this is the most important slide, because that slide deals with due process. What is it that trustees must do in order to have followed due process? And that is actually the key takeaway from this entire presentation. As retirement funds, to show that you complied with your fiduciary duties, you must be able to demonstrate that you followed due process. Now, that due process, the end result will be a weighing up of interests. There's another very important decision, SA Metal Group versus Chefta, where the High Court found that the retirement fund was weigh up the competing interests of the employer versus that of the employee, and then exercise a discretion. I've quoted a bunch of case law that actually underlines that. That's not important for purposes of today. But if you have time and you have interest, go and read them. Then ultimately, when the fund's decision is questioned by any of the parties to the dispute, the forum that adjudicates that question will say, did the fund apply its mind appropriately, impartially, and in a balanced manner in deciding to withhold a benefit or not? So the fund cannot simply rely on the fact that the employer has put forward to them a substantial case indicating that they are likely to succeed with litigation. Then the element of dishonesty. So I've included a lot of slides on this particular one because I do think that actual legal reform is needed in terms of amending the Pension Funds Act itself. And it's based on the following argument. I'm not going to deal with all the slides despite me including them. I hope you find it interesting. I'm not saying I'm right. I have quoted in the slides the views of Professor Marumwagai from WITS, who's an esteemed pension law expert. And I agree with his argument, and you can read that in your own free time. But the wording of Section 37D says that you can only make deductions if the employee was guilty of 4 things. 1, theft. 2, dishonesty. 3, fraud. And then it says, or misconduct. Now, just by interpreting those words in a literal fashion, it says to me that the legislator intended 2 categories. The one category consisting of theft, dishonesty, and fraud, and the second category consisting of misconduct. And you can read there in italics is Prof. Marumwagai's views, where he underlines what I just told you. But the adjudicator and our courts appear to have placed dishonesty at the center of the analysis when determining whether retirement funds are entitled to withhold their members' retirement benefits or not. I've quoted a number of determinations and court cases there. All of them underline that both the adjudicator and high courts feel that there must be an element of dishonesty. There I make the point that in other international jurisdictions such as India, the element of dishonesty is not required. So there's an international trend, you could say, not to place reliance so much on dishonesty necessarily. Most importantly for me is the fact that if an employer decides to institute legal proceedings against an errant employee, they would typically institute a delictual claim. Now, a delictual claim just means that the employee acted in an unlawful manner, and that can be that can include negligence, and where such unlawful conduct led to pure financial loss. I think that is the clearest potential proof that it should apply to cases other than just dishonesty. Now, I've told you that there are academics, some of whom I agree with, make the point that you should be able to make deductions from members' benefits, even in cases where there was just negligence or gross negligence. What do? Retirement funds, because you have to still run your fund. You can't run your fund based on academic opinions, or Lips opinions. And therefore, I have to caution that a conservative approach is the best one. The facts of each case is different, and I'm going to tell you why I say that by quick reference to the case of Denell versus Mr. Mafalo, which is a very interesting case in this particular, in this sense, because Mr. Mafalo at least appears to not be guilty of the typical fraudulent, dishonest misconduct in this case. In November 2014, due to a payroll system error, Denell paid an amount of 1.9 million rand into Mr. Mafalo's bank account. His actual salary was only 10,100 rand per month. Okay? So what typically happens every year around this time is people break for the holiday season, and when Denell's payroll persons came back to the office on 8 January 2015, they discovered to their horror that they made this huge overpayment into Mr. Mafalo's account. They immediately took steps, and FNB froze Mr. Mafalo's bank account. At the time when they froze his account, only 1.1 million rand of that money was left in his account. So he'd already spent about 750,000 rand of that overpayment. So obviously, Denell launched this application in the High Court to get an order that Mr. Mafalo be ordered to pay back that 700,000. But part of the relief that they sought was that Mr. Mafalo's benefit in the Denell retirement fund also be paid to the employer in terms of the provisions of Section 37DB. 2. Now, I think you will agree with me on a superficial analysis of the facts that this is not typical misconduct by Mr. Mafalo. In fact, he had no control over the conduct by the employer by which this amount ended up in his account. But the High Court went further, and you can go and read that judgment. It's freely available on the internet. The High Court came to the following conclusion, and they said, by virtue of the fact that Mr. Mafalo used this money, knowing fully well that this money wasn't due and payable to him, he satisfied the element of dishonesty that is required to apply Section 37D for purposes of making that deduction. So you can imagine different cases, different outcomes, and therefore tread carefully. But I want to repeat my advice at the beginning of this court case: follow a conservative approach. Then another area under this topic that you have to tread carefully is an admission of liability. So you can make the deduction in two events. The one is if you admitted liability. Number two is if you have a judgment in your favor as the employer, right? But there was a very interesting case that has currently not been decided finally. There at the bottom of that slide, Edward Snell versus Rachlau and others. The facts are as I summarized it for you in that slide. Mr. Rachlau he became entitled to a withdrawal benefit at Old Mutual. When he left the fund, he had a benefit of about 763,000 Rand, but he had signed 2 acknowledgements of debts in favor of his employer, Edward Snell. The one document reflected an amount of 4.091 million, and the other one 2.142 million. So material differences between the amounts that he had signed liability for. The employer wrote to the fund, Old Mutual, and said, please withhold payment of Mr. Rachlau's benefit, and the fund complied. Mr. Rachlau then complained to the adjudicator and said that it's an illegal withholding, and the adjudicator agreed with Mr. Rachlau and ordered the employer and the fund to make payment of Mr. Rachlau's benefit to him without delay. The employer then applied for a reconsideration of that order in the Financial Services Tribunal, and the following points came out in the Financial Services Tribunal consideration of the matter, and it said a valid written admission of liability must be clear and unambiguous, both as with regards to the liability and the amount. Secondly, simply initiating criminal proceedings is not sufficient to meet the judgment obtained. And the FST found that the PFA cannot simply override the trustees by ordering payment without the trustees having exercised their discretion. So that decision by the adjudicator was set aside and it was sent back to the adjudicator. We, as far as I know, and I make regular follow-ups, the final decision in this matter has not been issued, and that would be by means of a second determination of the adjudicator. And the legal issues that will be determined when they do make their new decision public is that there are 2 acknowledgements of debts for 2 different purposes. The one relates to a Section 37D deduction. So Mr. Rachlau said, I acknowledge that my entire benefit can be paid to Edward Snell as my erstwhile employer in terms of Section 37D. But he also signed a second AOD, and that was with regards to the balance that would remain outstanding and payable to Edward Snell. Remember, the total damages was about 4.1 million. So if his benefit was deducted, that still left an amount of more than 2 million. So what Edward Snell is arguing is that it's not really 2 different benefits. It's 2 AODs for 2 completely different purposes. They also said when Mr. Rachlau signed his acknowledgement of debt, there was still a pending forensic investigation. So, the amount could not, be established at those early stages to an amount of certainty as required, perhaps by the pension funds adjudicator. On this slide, I have quoted a few adjudicated determinations where they did allow 37D deductions, even though the amount in the admission of liability was not specified with certainty. In the first one of Charles Masinga, the employee actually just sent a WhatsApp to the employer to say, listen, I acknowledge liability for the full amount. No mention of the exact amount that she admitted liability to, and the adjudicator allowed it to happen. So we anticipate the outcome of that determination, and it becomes available. We'll share it with you through a legal update or whatever the case may be. Then the last subtopic under this point before I conclude is the issue of criminal proceedings versus civil proceedings. And this relates to the fact that there was a period where the adjudicator previously held that if you want to consider a withholding request from an employer where only criminal proceedings had been instituted, you would not be allowed to do so. But the Pension Funds Act was amended formally from 1 September 2024 when the two-parts regime was implemented, which now makes it clear that criminal proceedings are indeed sufficient. So you can go and read the issue of Edward Snell versus Bia. So it's funny that it's actually the same employer. And what I learned then later is that both the cases, this case and the one before it, actually stem from the same course of events. These two employees of Edward Snell actually form part of the same alleged scheme that led to the 4 million odd damages to Edward Snell. But in this particular one that I cited in the slides, the NBC Umbrella Retirement Fund was actually a respondent too. And in this case, we have received the adjudicator's revised determination, and the crux of which was that for purposes of withholding a person's benefit in terms of 37D, if that discretion is exercised by the retirement fund after 1 September 2024, criminal proceedings are indeed enough to justify a lawful withholding. Remember that I told you that this is, I'm going to get to a point where I tell you this is the most important slide. We have reached that now. This is the most important slide. So I've tried to summarize a few of the practical things that are not written into the wording of the Act itself. This is what you need to do when you leave the office today. With one caveat, you also have to distribute it to all of your other colleagues who work in HR who may not be in this presentation today. The first requirement is that the employer must write to the fund in terms of the fund's rules and wherein they state the brief factual synopsis of why the employer feels that the employee owes them damages. They must describe the element of dishonesty in the alleged conduct. They must specify the amount of the employer's alleged damages and also make reference to the legal action and the progress with the legal action that the employer intends to institute. That's fairly simple. The fund will then write a letter to the employee on behalf of the fund and then give that employee an opportunity to state the facts based on which he believes that the employer's damages claim against him will not succeed. And you will also give him an opportunity to give grounds based on which the employee believes that he will suffer irreparable harm if the benefit is withheld instead of paid to him. Then lastly, once the fund has received both the employer and the members' response thereto, the fund will weigh up the competing interests and exercise the discretion. Now, in order to pass the legal test whether that discretion has been exercised properly, you will have to satisfy the following three requirements. Number one, you must be able to show that you considered all relevant factors. Number two, that you ignored all irrelevant factors. And then thirdly, that you didn't allow your discretion to be fettered in any manner. And then lastly, that I didn't put on the slide, is you have to continue following up with the employee with regards to the conclusion of the proceedings. So that brings me back to my poll question right at the beginning. Can Mr. Zuma's pension benefit be used to pay that 28.9 million rand in legal fees? And I think the first observation to be made when we seek an answer to that question is the fact that Mr. Zuma's benefit is not governed by the Pension Funds Act. So all of the protections that I spoke to you leading up to this point does not apply to his benefit. He's a member of the GEPF, and therefore different pieces of legislation will apply to his benefit. So what Mr. Zuma is receiving is not a pension as such. It has a very typical and very different definition in terms of the Remuneration of Public Office Bearers Act. Section 2 of the Public Office Bearers Act benefits makes it clear that because the amount is determined in a very special way, that it is at least theoretically possible to use Mr. Zuma's benefits in the payment of those damages that is alleged to have been suffered by the employer. I apologize. I realize I've gone over my time. I do want us, Shweta, okay, I'm going to hand over to Kuketso Ne, and then we should try to answer a few of the questions. All right. Shweta, will it be okay if we go over time for a few minutes? If you can just indicate in our chat function if there will be a problem, if there's an overrun of maybe 5 or 7 minutes. In the meantime, let's tackle these questions. The first one, this looks like one for you, Kia. If a long period expires between death and a 37 decision, some of the beneficiaries may have died, or their age may differ significantly. Very, very good question, Kia. How would you deal with that question?
So I think the first thing that I want to remind our audience is that the purpose of Section 37C is to ensure that those who were reliant on the deceased financially are not left destitute. So the first question that you need to have and continuously have in the back of your mind is that. So if the answer to that question is affirmative, meaning yes, you would then classify the identified dependents accordingly, either factual, legal, or future dependent. And anything that happens thereafter should only have an effect on the allocation portion of the death benefit. For instance, as have been highlighted, if someone dies, then what we would then do as trustees would have to then highlight the fact that as at the date of death, that person was identified as a dependent, but now that they've passed on, the fund then resolved not to allocate any portion to them. And if age is a factor to be considered, for instance, a minor child now has become major, and let's just, for argument's sake, say that they have now obtained a job or education that would lead to them having a job and an income. That change in factors would then only have an impact on the allocation, but not them being identified as either a legal dependent or a factual dependent. Thank you, Lee.
Thank you, Kia. I think that is a difficult question, and with all due respect to the Constitutional Court, it would have been great if the Constitutional Court had dealt with that practical aspect as well, because that would have given the industry an indication that it's very difficult to lay down hard and fast rules when you are dealing with a section that is fundamentally having a social impact. So, I think with that, I'm going to conclude. Then, Nandi, your topic elicited a lot of response. I'm going to go through it. I think the most important one there is, do the members get the interest? And I suppose it means the late payment interest. Do the members get it?
Thanks, Lee, for the question. So I would say they do. They get it because the LPI is essentially to compensate members for the investment growth that they would have missed out on. Yeah. So it's important to...
Okay, but that leads me to the next question. I agree with you, but we clearly have a thinking audience here, Nandi, because the next question says, what if the investment, and I think that is meant to mean, what if the investment growth is less than the contribution? So that would mean that employees who get the late payment interest is then benefited to the expense of other members who earned less investment growth. How would you tackle that question?
So when I considered this question, I thought of it in the angle that what if the investment is less than the interest? So when they were if you think about the investment, maybe it would have been 1,000 rand, and the interest then is calculated at 2,000 rand. So I think that because LPI is there to penalize the employer, it's then to the benefit of the members, because had the contributions been paid on time, there wouldn't be that discrepancy on the interest being more than what the investment growth would have been.
Yeah, Nandi, I think it's actually fairly established practice that what funds do is, if members are affected by the late payment of contributions, the trustees will not allocate the late payment interest directly to the affected members because of the regulated provisions determining that is money that belongs to the fund. The affected employees only gets the investment growth that they would have received had it been paid timelessly, and the surplus is then distributed amongst the rest of the members so that all the members benefit equally. The next question I see is from Arish. Arish, because you are our colleague, we're going to take it up with you offline so that we get to as many questions as possible. Okay, now we get to the parental leave. Nicole, you answered the first one. If the father gets parental leave, does he qualify for UIF too? Please just repeat your discussion of that question.
Okay, so right now, what the Constitutional Court did was it created this new regime, and then it left out actually discussing the practicalities of what happens with UIF. So UIF right now has to now go and change its legislation to ensure that it also is in line with the new regime. So for now, most likely they haven't changed it, but in future, once they change the legislation, they will qualify as well. But those are the practicalities that need to be discussed in Parliament to see if they're going to affect it.
It's going to create a few complexities, Nicole, because
Yes.
I think the Concord gave the Department of Labour 36 months. Is that correct? Now, can you imagine all the fathers potentially claiming parental leave for the next 36 months, compounded up to a certain date in the future? But here's a very interesting question. Are there any timeframes, Nicole, as to when employers are expected to have amended policies to align with this judgment?
So here's the thing, the judgment is already in place. So if you're asking for a specific date, there isn't one. You should already have changed the policies. So that's why I emphasized it's really important for employers to start looking at their policies right now, because you don't want to find yourself in a situation where there's a parent who's going to be going on parental leave in February and you have not changed your policies as yet. So there's no time frame. The judgment is in place now. We are in it. We are living it. So ASAP. That's the time frame.
So that's a cautionary note to all employers. If an employee comes to you today and claims to be entitled to parental leave in terms of the FAVAIT decision, they would not be lying. So it's not to cause panic or, but the fact of the matter is the judgment has already been issued and it's already in place. So the sooner the better. Nicole, last one for you. Do these changes, because you made a few proposed changes in your presentation, right? Which are more or less labor-related changes, which has an impact on retirement benefits.
Yes.
Do these changes have to be in the fund's rules?
So that would depend. Do your fund rules speak on maternity leave? I would look at that first, because those are the initial changes that we have to look at. So for now, I would say if your fund rules don't speak on maternity leave or leave of any sort, then I don't think you need to look at it. Rather look at like I said, the risk management of what you're going to do in terms of contributions when you have both parents now being absent from work. How is that going to work in terms of contributions of both parents now not being made into a fund?
Yeah, but at least I would imagine if you're going to allow for temporary absence, the payment of only risk premiums for the two or the various kinds of parental leave, then it has to be written into the rules. Where it has been limited to maternity leave in the past, you have to now go and amend your rules to make allowance for more. The next question is, can the employer request a fund to withhold a member's benefit due to absenteeism? No. So there's no element of dishonesty, even though it can be misconduct, and you can certainly make a case for financial damages. I just think you would be setting a very dangerous precedent if you... Colleagues, do you agree with me? Nicole, Kia, Nandi, you agree with me? Ne?
Agreed.
What if my employee signed an acknowledgement of debt for dishonestly accepting an advance on their salary, but resigned after payment was made? Can an employer use this to claim from their pension benefit? So my first response is, in general, if an employee took an advance on their salary, that would typically not be recoverable by means of Section 37D. But the question is worded differently. It says the employee dishonestly accepted an advance on their salary. So I don't know the facts. I'm left to my imagination. So I would imagine that this employee, knowing full well that they were going to leave at the end of the month, already asked for an advance on next month's salary. I suppose you could make out a case for dishonesty in that regard. But as a general rule, a deduction like this, like an advance on a salary or a study loan or other outstanding debts to the employer, are not recoverable in terms of Section 37D. Colleagues, you agree with me?
Agreed.
Okay. Next one. Would an act of breach of a work policy contract constitute misconduct? It depends. It depends on what level of culpability is involved. So you generally you get intentional misconduct or dishonesty, fraud and theft, or you get negligence. So let's say you're a driver and you work for a courier company and you make an accident with your courier vehicle. Typically, that would not be deductible from your pension benefit because you're guilty of negligence. I do leave open the possibility. You will remember that I argued in my slides that I don't fully agree that dishonesty be made central to the application of this act. I would, however, not advise any employer to incur legal expenses to go and fight this case, depending on the amount of your damages. I think with a good legal team, you can make a compelling argument where an employee stole your vehicle without your consent and then gets into an accident, and let's say your damages is R1 million, you may consider making that case. As the case law stands now, you should not be able to recover negligent damages from your employee. Does the parental leave, lastly, this is our last question, does the parental leave apply to a couple who cohabitate?
Yes,
Nicole?
parental leave applies to parents. So if you cohabitate, it will apply.
Yeah.
There's no need to be married, as long as you are the parent.
Absolutely. And yeah, I wish we could deal with more questions. Koketso, will you please conclude and summarize for us? Thank you to everyone who took the time to listen to us today. We really appreciate it.
Well, we've covered tremendous ground today, from dependency determinations in death benefits to recovery strategies, parental leave and employer liabilities, all critical threads in the fabric of compliant and member-focused fund administration. I want to extend my deepest gratitude to our exceptional lineup of speakers today. Thank you for sharing your expertise so generously. Your contributions have made this webinar a standout. A huge thank you goes to all of you, our attendees, for your insightful questions and commitment to advancing compliance and member protection in financial services. Your presence and engagement are what drives these sessions forward. It's been a pleasure hosting you. As a final note, please don't forget to claim your CPD certificate for today's webinar. It will be available for download immediately after we conclude. That's a wrap on today's session. Until next time, keep championing excellence in fund administration. Goodbye, everyone.